Well, let's get it going then. Welcome, everybody, to California Pool and Spa Association. This is a webinar for pool contractors specifically, and we're going to take about an hour of time with a special guest, Leah Schoen, from the Green Law Group. Now, Leah works with the Green Law Group, and they are a group of attorneys. They work primarily with contractors. I'll let her go into a little bit more detail when she introduces that. I'm Scott Cohen. I'm chairman of the CPSA and here to help answer any question you guys might have about pool construction. I work in addition to working as a pool contractor in California. I also work as a construction defect expert witness. I've done that for about 18 years now. So Leah, why don't you take it over? I don't know if it's Leah or Leah. I hope I'm not screwing that up.
Oh, no worries. Yes, it's Leah. Thank you. Thank you, Scott. Good evening, everyone. I guess it's evening. My name is Leah Schoen, and I'm an associate at the Green Law Group. My firm was asked to provide a presentation on pool warranties and new laws affecting contractors. I'm pleased to be speaking with you all today and want to thank the California Pool and Spa Association and the Pool and Hot Tub Alliance for this opportunity to provide you with this presentation. Thank you, Scott, for the introduction. I'm going to go ahead and click through. So a little bit about the Green Law Group. Our law practice was originally formed to serve construction professionals with contracts, licensing, and notices. As our clients' legal needs grew, our law firm expanded to meet that challenge. And today we offer a full range of services to help small businesses thrive. Our clients rely on us to make sure they're properly organized, their legal documents are in order, their employees are paid correctly, and their exposure to legal liability is limited. And so when our clients do go to court, we're right there at their side working to make sure that they prevail. I also want to introduce Easy Law Construction Notices. In 1985, Scott Green formed Easy Law Construction Notices to help contractors and others in the construction industry secure and collect what they earn. Today, Easy Law provides professional prepared preliminary notices, mechanics liens, stop payment notices, bond claims, and collection services for hundreds of clients throughout California. Oh, I'm sorry. Okay. It wouldn't be a presentation without some sort of disclaimer. So the information contained in this presentation is not legal advice. The law changes constantly with new statutes and court rulings. For legal advice, it's regarding California law and the facts specific to your case. It's best to consult with an attorney who has a substantial experience in your area of concern, or you can reach out to our office for assistance. So I think the area of the most interest and what we're going to spend majority of our time on is this question of how long as a pool contractor are you required to warranty a pool in California?
I get this question a lot, which is what prompted the reach out to have you guys put this seminar together for us. A lot of times guys have certain things in writing in their contract. Other times they're unsure. I've seen things like lifetime warranties written in contracts from pool contractors. And I want to ask you about that after you explain this. But the real question was, well, what exactly is a warranty, and how does the Contractors Board in the state of California see that?
Sure. So what is a warranty? I put up the definition here, but it is a legally enforceable assurance that you're providing as the pool contractor to your client regarding the quality, functionality, and durability of the work you're providing. That's a sort of generalized definition. There are different types of warranties. There's express warranties, which are the warranties that Scott was referencing about what's specifically stated in your contract. That would be an express warranty. It's specifically articulated and written in that contract. And that is considered a binding obligation, enforceable in court, by the way, outlining the things that you're promising to deliver to the client and the time frame that you will address any problems that surface. Then you have an implied warranty, which, unlike express warranties, are not specifically stated and expressed. They're implied by the mere nature of the construction work that you're performing. So by taking on a construction job, a contractor is tacitly agreeing to these warranties. There's generally 2 implied warranties. Warranty of workmanship, which is guaranteeing that many construction projects are built in good or workmanlike manner, free of defects, inclusive of labor and materials. And then there's warranty of habitability, which guarantees that the project will be suitable for the purpose that it's intended for and safe to live in and use. And most likely, for purposes of pool contractors, you're going to see warranty of workmanship and then also vendor literature on the materials and supplies you're utilizing. And the third type is statutory warranty, which is determined by state statute. So it would be California specific law outlining the amount of time that contractors are liable for any construction defects. So those are the three types of warranties. I'm going to focus mostly on the statutory warranties because I think, the express, what's in your contract. You should know what's in your contract. The implied is very sort of generalized. We kind of touched on that. And then the statutory warranties are where a lot of people get hung up, and it's probably the most unclear, unless you just really like to read the Business and Profession Code and California Civil Procedure. So the statutory warranties that California recognizes, and the one that probably most pool contractors run into in the immediate is this 1-year warranty that covers fit and finish. And I'll have another slide on that, but it is, a builder's expected to provide a homeowner or home buyer with a minimum of 1 year, an express written limited warranty covering fit and finish. But even if you don't have that in your contract, this still exists and you're still expected to be bound by it. And so you are still obligated for that period of 1 year.
Leah, I wanted to ask that in the slide prior to this, you mentioned the express warranty, and that's something you've written and put into your contract. Is a contract required to have a written warranty in it?
Regardless of whether you have it or don't have a written warranty, and there's nothing in the home improvement contract business profession code specifically stating warranty that I can recollect, and I was just looking at that earlier today. But regardless, there is an express warranty for your purposes of a year fit and finish, regardless of whether it's in your contract or not.
Got it.
Okay, and then so there's also this 4-year warranty on installed items, which you can find in the Business Profession Code, that they're guaranteeing against defects in compliance with building codes and manufacturer requirements. There's 2 to 5 year warranty for defective installation, which you could be liable for resulting repairs and damages for 4 years, as you can see from the 4-year warranty on installed items. And then there's this 10-year warranty, which I think a lot of people default to as being, oh, there's just going to be a 10-year warranty on everything. But really, it's for structural defects, specifically in 7109 and Business Profession Code 7091. And we're going to talk more about that as it pertains to those defects. And then the other one people also refer to is this, 10-year warranty for right to, new residential construction. And I don't know how regular that comes up, but generally for new construction, you should know that it's going to be 10 years. You're going to be stuck for 10 years if there's issues.
I wanted to ask a question on fit and fit and finish, but I also wanted to just point out, I think when you're saying here that this Business and Professionals Code 7091A, that it guarantees against defects, but not just compliance with building codes, but the manufacturer's requirements. So that means if you do not follow the manufacturer's instructions and what you install has failed to meet the anticipated use, it's not doing what it's supposed to do, you're on the hook for it. And so I think a lot of people in our industry take for granted they've been installing it the same way for so long, they don't bother to read the instructions. And I've come across this a few times recently in current cases where the deck jets or bubblers were not installed following the manufacturer's instructions. In fact, this comes up a lot with the shear waterfalls, and the contractors are on the hook to repair it if they didn't follow the manufacturer's requirements.
Yeah, and I think that's an excellent point. To keep in mind that installation is inclusive of the expectation that you are installing it correctly per manufacturer requirement. So absolutely. On the fit and finish warranty, the Civil Code Section's 900, and it states that, there's a warranty as to fit and finish items that a builder shall provide a home buyer or homeowner with a minimum 1-year express written limited warranty covering fit and finish. And even if you don't have that in your contract, that is the expectation. And it's specifically stated here as well. So no matter what, there's going to be a expectation of a year. Going to defects. So one of the things, we were talking about structural defects, and then there's also, the defective installation. There's 2 types, latent and patent defects. Latent defects are ones that are not apparent by reasonable inspection. These are ones that isn't obvious to anybody generally. They are things that surface like structural cracks, broken pipes, defective pool fitters, drain pump defects. These are examples. And the latent defect, basically the warranty is such that states that no action can be brought to recover damages to real property more than 10 years after the substantial completion of the development or improvement, which would be also your substantial completion of whatever scope of work that you're performing. The patent one is the one that's much more obvious. It's apparent by the reasonable inspection. Examples I have here are like a low staircase banister, paving stones that are raised, that's a tripping hazard, a defective landing, not having a swimming pool fence, or defects involving stairs and guardrails. And that has a much shorter statute of limitations period of no more than 4 years after the substantial completion of such improvement.
Going back to fit and finish, because that's, you're warranting that for just a year automatically, whether you want to or not. Is that referring to just aesthetic things as well? You have a client, let's say there's a tile, you've got a natural stone patio and a few of the stones are a different color because that's the natural way it is with stone, but we get that question a lot. Is that a fit and finish item? What would be an example of a fit and finish warranty item?
Yeah, I wouldn't say that tile, especially with natural stone, because it does obviously vary and it's not specifically manufactured. That is not considered a fit and finish item. I would say, fit and finish items would be, surface items, but, that can be addressed that are not specific to the item itself. So I actually have a pool contractor that I represent, and I recommend to him, there's usually natural stone disclosures and disclaimers that are provided when you purchase these materials. And it's best to produce that along to the home buyer, because most of the time it will state specifically that this is a natural stone, that theirs is going to vary. It could also change in appearance over time. So those are things that people, contractors should really look to pass on. But fit and finish is more of, surface, aesthetics, not going to the heart of like the materials and supplies. Does that make sense?
It does. Thank you for clarifying.
Okay. So, I think there's some people say, okay, well, what's the difference between, what's the statute of limitations versus a warranty, and kind of they get mixed up. And the difference is, the statute of limitations is the time period during which a plaintiff, or in this case, a homeowner, can file a lawsuit after they've been harmed. So the warranty period is the time in which you are providing that coverage that you are going to, come in and repair or fix. But the statute of limitations is the time period where that plaintiff can file a lawsuit after they've identified a harm. It may be from defective work product, it could be negligence, it could be, you name it. But that's that time period that they have. And unless that time limitation is waived, meaning they've expressly waived that, or it's told for some reason. I know in COVID cases, there was a tolling. Plaintiff's failure to initiate that legal action during that time period will foreclose them from being able to bring that claim. So, a little bit of peace of mind, but let's go into the statute of limitations periods. So, I think what I mostly run into is the breach of contract, right? So a plaintiff can bring a breach of contract cause of action in a lawsuit 4 years from the date of contracting. or 4 years, well, 4 years from the date of contracting generally may be breached depending. The other statute of limitations periods are like injury or damage to real property. They're gonna have 3 years to bring a claim. Premises liability, negligence, pool accidents, that's 2 years. And then that patent defects and latent defects, that's gonna follow along with that same warranty period. So patent defects, it's gonna be 4 years from completion. And again, those are obvious defects. And then latent is gonna be 10 years from substantial completion, not necessarily obvious. Also known as a statute of repose, which it serves as an absolute bar to plaintiff's right of action, preventing them from bringing that action. It's independent and it's objectively determined from a verifiable event. So it could be, whatever that substantial completion date would be.
So Leah, is that we have a question in the chat. When does this timeline start? Is that when I signed the contract or when I got the final inspection on the project?
The statute of limitations or warranty?
Well, I think it's the same question for both.
Okay. Breach of contract would be 4 years from the date of contracting.
Okay.
Injury or damage to real property would be 3 years from the date of discovery. And by discovery, not, by reasonable inspection, not I chose to ignore this and I didn't until recently discover something that was apparent. Like it's something that, the first time you got knowledge of it. Same with premises liability, and negligent would be the act itself, or the incident. And then the defects are from the date of your substantial completion. So whatever is constituting substantial completion, depending on what your scope of work is.
Okay, so client doesn't pay me the last $10,000 on a project. Am I required to warranty it?
Last 10,000 of
Sorry to hit you with a zinger.
Yeah, a little bit. So yeah, that's a tough one. I've run into this situation before, not in the pool context, where a client wanted a contractor to warranty something, but was also demanding a refund for that same amount. And my point to her was, you can't ask someone to work for free and then expect them to warranty work they never got paid for. So, this is obviously, depends on the facts. It's a, legal argument, but depending on what that value, what that money was supposed to be for, if it was for particular materials or for a particular portion of the work, I would argue that there is no warranty obligation. You weren't paid for the work that you did. Now, again, that's in the larger context of like, how much are we talking about? How much, so without more specifics, but that's the argument that I would be making. How could you possibly warranty something you weren't paid for? Okay, and then Scott had asked me this question yesterday, and I didn't know it for sure, so I verified and talked to actually Mike Khalil for just to make sure I was on point with it. He had asked, what obligation, if any, do I have as a pool contractor to honor a warranty that I was provided to a previous homeowner, or it would be, a previous client. And the statutory warranties still apply no matter what. And the argument there is because it runs with the project, runs with the work you performed. But the express warranties and the contractual side of it, that you're not obligated to withhold, short of it stating in your contract that it is a warranty that can be assigned or transferred. And then if there's any specific requirements to effectuate that transfer or assignment, that actually has to be done as well. Did I address your question, Scott, this time?
Yeah, yes. So there are times where, a homeowner will make some recommendations as contractors or designers to a homeowner about a specific, let's say we're choosing a paver and we're like, what, this particular material is really slippery. I don't recommend it around a swimming pool. And they say, well, you know what, I think I want it and I don't care. I just want it to look good. That's more important to me, to heck with the kids if they slip and fall. And so we might say, well, okay, we want you to sign a disclaimer, what have you, or whatever. But now the property's changed hands. 6 months later. It's a new homeowner and there's a slip and fall on the pavers and it comes back to the original contractor. I think your point and the answer to my question is you're on the hook. So just because one homeowner says it's not important to them, you're still on the hook for 4 to 10 years, depending on what it is. Don't make an exception for a particular client, because you could be carrying that responsibility for the next 3 homeowners regardless.
I think that's the more conservative approach by far, just not to expose yourself. The only other caveat I would add to that is if you've gone out of your way to provide that disclosure, selling a home, there is a certain notice requirement and failure to disclose things that do surface. So if you're providing that notice and you've got that execution of this disclaimer, they have been provided with notice. And they really should be providing that to the homeowner and the real estate agent to provide that to the new homeowner. But overall, I do think that your recommendation is the more conservative of all approaches.
Thank you.
A couple points I just wanted to raise, and so I put it in here, was the business and profession code require, and I threw it in. I know it's a little convoluted, but as it pertains to pool contractors, which the primary purpose of which the construction of a swimming pool that does not comply with paragraphs 4, 5, 7, or 8, or 9, which is of 7159, which by the way is the whole business and profession code section on home improvement contracts and what your home improvement contract needs to have on contract requirements and the items that need to be included or may be provided as an attachment. And failure to comply with the home improvement contract requirements, it could render your contract void or unenforceable when you go to try to file suit on that contract for a breach of contract, whether it be payment or failure to comply with whatever those terms and conditions may be. You don't want to be in a situation where you think that you have a contract that's enforceable to find out that it's not.
I want to elaborate on that a little bit more in pool contractor language. So these, she's going to go over 7167 and 7168. And these are 2 statutes in the building and professional code that affect only swimming pool contractors. It's the only classification of contractor that's under these specific restrictions. And what that 7167 is saying is that if you're missing some of the things that you have to have on your contract, like a progress payment schedule, or you didn't fill out the progress payment schedule, or you don't have completion dates, or you don't have a notice that you of lien rights, or maybe you didn't include a copy of the contract or a copy of the plan with your contract, these would be considered substantial misses from the 7159, the HIC, the home improvement contract requirements, and then your contract is unenforceable for your side. It's not unenforceable for their side, it's unenforceable for your side. So pay close attention to what she says next.
Right. So then you're largely, you don't now have a contract you can work with anymore. And you're stuck dealing with sort of what would be an equitable argument that you should be paid for the services you provided. And that is the 7167B. So whatever's in your contract, if you're like, oh, I'm protected because of this, that, or the other, if you don't comply with all the home improvement contracts, you cannot, feel covered necessarily by any other terms and conditions you may have. The other side is this Business Profession Code 7168, which is for swimming pool contractors only. And if your contract, whatever you have in your contract, it doesn't matter in this case because you have statutory requirements that state that in an action between a person that has contracted for the construction of a pool and a pool contractor arising out of a contract, the court is going to award reasonable attorney's fees to the prevailing party. So the party that wins will have an automatic right to their reasonable attorney fee recovery.
I would like to elaborate on that just a little bit in that, so regardless of what it says in your contract, that the prevailing party is going to be entitled to their attorney's fees. And the reason this is a big deal is because any attorney with an expert witness can walk onto a property and find $10,000 worth of things you did wrong on just about every project you've ever built. And your insurance, your general liability insurance, will cover work, not the work you did, but the resultant damage of the work you did. So if if the pipe breaks, they don't cover the broken pipe, but they cover the damage the broken pipe created. And sometimes I see contractors get very fighting in these cases about it's the point of the thing, it's the point of the thing. Well, if you go to trial arguing, it's just the point of it, your insurance company doesn't cover your legal fees if you lose. And if the prevailing party gets their legal fees, you might only have a $10,000 loss in a case, but the legal fees might be several $100,000. So be very, very careful. That 7168 is a big deal. And one of the things that we've been doing at the California Pool and Spa Association for the past couple of years is working with the Contractors State License Board to see how do we get rid of these two statutes, because they're not fair. They specifically call out pool contractors. There's no other contract classification that has to deal with this. And my plea to the board was take these laws away or allow us to have continued education for our contractors as a requirement, because their response to can we have continued education for contractors be a requirement, and their answer was, well, we can't treat pool contractors differently than we treat anybody else. Well, that's not true. You've got two statutes on the books that you are treating pool contractors differently. And in fact, you're giving attorneys a pretty guaranteed paycheck at the end of the day if they're suing a pool contractor. Now, Leah, one of the questions that came up was in the chat, is this just for new construction? Do these on the hook for the laws and the 7167 and 7168, do those apply to remodel work as well? Because this says any work involving a pool, and it does involve,
Yes, it's not limited to new construction, new buildings. It's inclusive of improvements and remodels.
Interesting. I think what's really interesting about this is that they're now allowing general contractors to build pools, and they're not covered under this. It specifically says pool contractors, right?
Yeah, the home improvement requirements, and it's not 7167, but all contractors have to still comply with those HIC, and you still run into the void and unenforceability issue. But the attorney's fees, that is special for swimming pool contractors.
Horrible.
Sorry?
It's not right.
Yeah. Well, and attorney's fees, it's sort of the tail that wags the dog, unfortunately, in a lot of litigation. It ultimately comes down to that. And so it's definitely a make or break code provision you should definitely be aware and cognizant of.
There was a question here, and I don't know if you want to take these at the end or you want to hit it as we go, but one of the questions is, what if the contractor files bankruptcy during the warranty period?
And assuming in that situation that it wasn't like a liquidation where it was bought by another contractor who would necessarily be obligated under those same terms and conditions. I mean, if the materials is the same, obviously that's not affected, but there is no warranty and there's no licensed contractor to pursue in the event that, you file bankruptcy and you're no longer operating. So there is no warranty.
Yeah, it's a tough call, because I think if you file bankruptcy, but there's fraud involved in their claim.
Oh, well, fraud isn't dischargeable in bankruptcy, but they can't also compel you to perform work as part of it, but there may be a value to the damages. There's that potential argument, but again, they would also have to prove up the fraud in bankruptcy, and then everything would be discharged short of the fraud. Is generally how it would work. And then the other thing I just want to mention, because we were talking about, you know, the bankruptcy, and I don't know how many people are aware of this, but I like to bring it up every time with opposing counsel when they sort of say, well, my client doesn't have any money and et cetera, et cetera. If there's a judgment that's entered against you as a contractor, that judgment just needs to be provided to the CSLB and they will suspend your license until you pay that judgment. And it's not just any judgment, it's a judgment out of the contractor services you provided. And I would say that that is, you know, that's a significant tool for a lot of consumers to utilize. They don't necessarily know, but that judgment, that will haunt you and that will prevent you from being able to renew your license and it will stay suspended. So just keep that
I
in
have
mind.
seen the CSLB pull licenses for $1,000.
Oh, yeah, absolutely. And all it takes is a letter and a copy of the judgment. And they will keep it suspended until, you know, if there's a payment plan entered and they're good on that payment plan, because, you know, it's an enforceable judgment out of the work that you performed under your license. So just wanted to mention that. It's sort of an overall sort of list as a takeaway, because this is sort of a very specifically focused presentation. I just wanted to give you some general notes about limiting your risk as pool contractors. You know, make sure your license is active at all times during the performance of the work. You don't want to run into a discouragement issue because you're unlicensed, or your bond is no longer because you're not licensed. So just make sure before you
Can you
start work.
explain what disgorgement means?
Sure. Disgorgement is a very draconian, and I'm sorry I didn't put it up here on the business profession code citation, but it basically states that if you are not licensed while you're performing work, that would be a basis to force you to return all money you earned for that job.
All the money that you earn for that job if you let your license lapse. This
Yeah.
is also a problem if you work outside your classification.
Mm-hmm.
If you're a pool contractor and you're working at the house and you do the front driveway for the client, if you don't carry any other classification other than C53, you have no business doing the driveway. And I know of a case where the pool contractor did the driveway, he did the entry gates, he did iron gates going up to the driveway, and he was not licensed to do so, and he could not enforce his contract, and he was required to disgorge, give back all the money for those items that were outside his C53 classification. Be careful.
Yeah, that's great. And thank you for that example. Yeah, I've seen it. It's, you know, even a very short window of time. You just don't want to be caught in that situation. So make sure you check your licensing, that it's current and active before you're contracting. The next would be to use written contracts that comply with the business profession code. We just talked about how home improvement contracts need to comply and that you run the risk of it being void and unenforceable. So make sure that your contracts are complying. If you have questions, you can reach out to us. I'm probably
Is
one
that a
of,
service you guys offer to review contracts?
yeah, we will
Oh,
review. I think I may be one of the only ones in the office who've gone through line by line and been like, this needs to be 12-point font bolded, et cetera, because, and not that that's going to be the make or break, but you just don't want to give the CSLB any excuse to give you a hard time. Just why put yourself in that situation? The next recommendation is make sure the contracts are signed before you start. Don't try to get them to sign after you've started. Then you're asking for a bunch of problems. So just make sure you have your contract signed by the property owner before you start working. The next would be make sure your change orders. First of all, make sure you have change orders if there is a change in the scope of work you're providing, and then make sure those change orders are signed by the property owners before you perform that work. The next would be make sure you're maintaining your workers' compensation insurance, and that you have your general liability insurance in place on every project. I did, last year I did a whole presentation just like this on commercial general liability and what exclusions to look out for and the scope of work. So you can find that on our YouTube channel, which there should be a link on our website. Yeah, commercial general liability is definitely something that surfaces often, and people think they're covered, and then lo and behold, it's an exclusion. The next one I would say, make sure that you're only using licensed and insured subcontractors, and you're engaging in safe workplace practices, to avoid just unnecessary exposure. Make sure you have written subcontractor agreements. I know a lot of people don't, and it can be very informal, but you don't want to be in a situation where you're trying to enforce an oral agreement on something.
No, Leah, we take that a step further and we ask them to sign for our company as additionally insured.
Yes, so absolutely. And there's and I just had this conversation with someone today. There's a difference between certificate holder and additionally insured. So you want to make sure that the general contractor is the additional insured, because then you're going to be covered under the policy, assuming, the endorsement was done, etc. Versus a certificate holder. And some people think, well, oh, I'm covered because I'm listed in the certificate holder window. But all that means is that there's a valid policy and that it was issued to you as proof of a policy. That does not mean you are insured under the policy. The next one would be require owners to sign off on design and specifications prior to construction. Homeowners are going to change their mind. That was or was not agreed to. Here's different versions of the same bid. Make sure the one that you're moving on is the one that is executed by the owners. And make sure you're creating a strong paper trail to support your position in the event of a dispute. I know it could kind of come off a little paranoid, but it's gonna come up. If you end up in my office, I'm gonna say, well, did you take photos? What's your documents? Do you have notes? Because it's always gonna come down to that. So do yourself a favor, take the photos, as you're going along in the project, once you've completed the project, and just save yourself that headache. The next one would be to consider using mediation provisions or arbitration provisions to resolve disputes without litigation. Some can be less costly than litigation. It seems like it's getting increasingly more expensive, but it's something you may want to consider to avoid immediately having it go to litigation. The other is, it may assist is to use project management software to help you maintain project schedules. And then just providing outstanding performance and customer service is going to avoid a lot of disputes. And I would say 90% of the disputes that come across my desk that are in our office are miscommunications. So, try to hedge that at the pass and get things in writing, and just provide great customer service.
There's a couple of questions here. One says, I've seen too many contractors not submit change orders and then at the end submit a much larger invoice. Is that final bill enforceable? And I think we know the answer. That's absolutely not, but go ahead.
Yeah, the business profession code specifically states that if you do not have a change order stating executed, good luck trying to recover the value on that change order.
Yeah, if it's not, there's no such thing as a verbal scope change. If the client wants something extra, you fill out something in writing, you tell them the price, and you should also include the additional time that change is going to create. If that project's going to take a month longer because they want a special tile that's coming from Italy or what have you, make sure you put in that paperwork that's costing you time, because they'll later forget about it. And it's very important to have these subcontracts or scope changes signed immediately with the homeowner. And emails are fine. A napkin is fine. The back of a business card is fine. Just get it in writing. One more question for you here. Regarding contract signing, is the 3-day rescission the same whether signed at the residence or the pool contractor's office?
I'm not aware of any limitation on location of signing. The only limitation I'm aware of is the 3 to 5 day limitation, and that is based on age of the individual. But whether it's signed in the office of the contractor or at the residence, I'm not aware of. I can check that, but I'm not aware of anything that's limiting that.
Yeah, I think there is, like, I know when you buy a car at the actual dealer, you don't have a right to bring it back for 3 days. There's no 3-day right to rescission. But I would say, regardless of what it says, if somebody wants to cancel within 3 days, you let them do it. And
But ask for it in writing, not verbal.
right. And then it's I'm not sure if a lot of pool, if everybody's aware that they did change a law in California. I don't know if you're going to cover this in next part, but if you are 65 or older, you have 5 days to cancel. And on all of your contracts, there has to be a notice of the 3-day cancellation and a separate notice for seniors of a 5-day cancellation clause. And that's something new. They aren't great about communicating these new things we need to have on our contracts. But if you're missing it, it could be the thing that you're missing that makes your contract unenforceable.
Yeah, I'm actually not going to talk about that specific part because I'm only going to focus on the most recent legislation, but that is definitely part of my checklist on home improvement contracts. So if you end up reaching out to request a review, that is, you don't have it, I'm going to point it out to you. And also, hopefully, we'll have another presentation where I will just spend time on home improvement contracts. And I'll have a checklist for you and you can go through on your own and see, do I have all of these things in place?
That sounds great. We talked about maybe doing that spring next year, right?
Yes. So this is going to be that's the portion on the warranty liability side, statute of limitations. And then now I'm going to transition into some of the newer laws affecting contractors. So I have a high level list here, but I'm going to go through them specifically. This actually started from a presentation I gave in the beginning of 2023. And something to note, I do post around November because the legislative session's end of June, and I'm sort of a geek for laws and public policy, and I have a master's in public administration. So I'm always like, oh, what's the newest laws? How are you going to be affected? And I always post an article on our website with the upcoming laws that are coming into effect as of January 1 and how it affects contractors. So look for that. You can also subscribe to on our website, and then we'll also send you the notifications when new articles are posted.
One more question just before you roll into the new laws. In the question, it says here, in working for a general contractor as one of many subcontractors, are any of these rules that apply to home improvement contracts applicable? So if I'm working for a general contractor instead of a homeowner, do all the same rules apply?
No, because the home improvement contract is specifically for homeowners, and the requirements in there are specifically to protect homeowners. What you have with your GC and what we refer to here is a master subcontract agreement or just your subcontract agreement. Those are the terms and conditions of your contract with the GC. Now, the GC should make sure that if they're the one providing the contract, it covers all of those similar requirements in the home improvement contract to avoid issues that would be experienced at the client end, at the end user end. But there is not HIC requirement because that's not the purpose of the legislation. It's to protect the homeowners.
That's a good question. Thank you for the answer.
Okay. So I'm just gonna go through some new laws. Actually, I think. Okay. Well, so it's not up here, but the minimum wage changed. I'm sure a lot of people are aware of that. Starting January 1 of 2023. The minimum wage is no less than $15.50 per hour. It could change. Could be different by city and counties. And so there's also a minimum salary requirement annually to exempt for purposes of overtime. So if you are not aware of that, you can also go to our website, and I have a detailed paragraph about that. But moving on to the next one is new workers' compensation requirements. So the CSLB issued a bulletin in the end of 2022 announcing the enactment of Senate Bill 216 and its implications for licensed contractors. It started to include a lot of additional license classifications as being required to obtain workers' compensation insurance coverage, even if they have no employees. That's the key point. And this requirement ultimately is going to extend to all license classifications on January 1, 2026. So even if you're not part of this ever-growing list, everyone is going to be stuck with making sure to have their workers' compensation insurance coverage by January 1 of 2026. And you know, obviously a lot of contractors are subject to this now. The only exemption, there's a very minimal exception for joint venture licenses, and you can file a certificate of exemption. But there's additional information on the CSLB website about complying and avoiding potential legal action or penalties from the board. And one other caveat I just want to say is a lot of some disputes that I've handled in this office are also like workers' compensation audits, right? So not properly classifying your trades and reporting it properly, and then you get hit with a big workers' compensation premium bill at the end of your policy period. So make sure you have it, make sure you're properly identifying your employees, or if you're not, that you have the proof of insurance so that they're already covered and you're not expected to cover them.
Yeah, I have seen contractors play games with having, let's say, 20 people on staff, and they only have 10 of them on the books. So they're really only covering 10 of them with workers' comp, trying to save costs, but still comply with the CSLB requirements. I know of one contractor where the guy who was actually not only was he off the books, but he wasn't even a US citizen, and he fell back onto rebar and impaled himself. And that contractor went completely out of business. And it cost him his marriage, it cost him a whole lot of things, and of course, entirely his business. Don't try to save a little money by bending these rules. The work comp is there to protect you too.
Yeah, there's thankfully a lot of cases it's just about getting the proper documentation and paperwork, but you don't want to be in that situation, because the last thing you want is an unexpected bill at the end that you're trying to cover. The next one, and this is one that came into effect in January 1 of 2023 on the increased license bond amounts for contractors. It went up from 15,000 to 25,000. Bond of qualifying individuals increased to 25 from 12,500. This change was codified in section 7071.6 of the Business and Profession Code. And the last time the bond amount was actually increased was in January of 2016, when it jumped from 12,500 to 15,000. And so this is in reference to the surety bond that's required to secure your license, that is available and on display for all consumers on the CSLB website. So the other thing is, you know, if your bond goes inactive, your license will eventually go inactive. So make sure you're keeping up with your bond.
And they used to allow you to put money in the bank in a CD instead, and they no longer allow that.
Okay, so then the next one is the Cal Savers retirement savings that passed in January, as of January 1, 2023, expanded access to Cal Savers retirement program by requiring employers with at least one employee to register for Cal Savers by December 31 of 2025 if the employer does not sponsor a retirement plan for its employees or register as exempt. So if that's something that pertains to you, make sure that you are either having your own plan, that you are registering for Cal Savers, or submit for an exemption. For the next one is wages and payroll records for public workers, employees. It creates a database to monitor compliance with prevailing wage regulations. I don't know how many of you work for public works projects, but prevailing wages is generally what I see, especially in, you know, AIA contracts, but more and more contracts. So this will create that database. Contractors and subcontractors must also submit a copy of their certified payroll records to the trust funds in accordance with federal law. So if you do a lot of public works, you're going to want to make sure to read up on SB 954. It doesn't change existing labor laws or regulations, but it's an additional tool to help monitor compliance with these laws and regulations. Designated person under the California Family Rights Act. This amended it by expanding the class of individuals for whom an employee can take leave to now include a designated person. And that designated person is defined as any individual related by blood or whose association with the employee is the equivalent of a family relationship. And so this is now extended to stepchildren, same-sex partners, domestic partners, foster children, legal wards, or other persons that are specified. And then they're eligible for 12 weeks of family care and medical leave. And so AB 1041 requires employers to provide written notice of this amendment to employees within 30 days after passage, which we're well past that. So hopefully everyone did. If you have, if you have those employees that need to get notice, failure to comply could result in civil penalties, as most of anything when it comes to employment stuff. We have a fun little red marking here. Okay, so then the next one is prevailing wage and hauling on public works projects. So it's AB 1851, which required drivers of vehicles used for hauling materials in public works projects to be paid the prevailing wage. The California Department of Industrial Relations is responsible for the enforcement of AB 1851, and it ensures that all contractors comply with the prevailing wage requirements. And so if that is, again, if you engage in a lot of public works projects, that's definitely something you're going to want to check out. The next one is bereavement leave. So AB 1949 made it unlawful for an employer to refuse to grant a request by an employee to take bereavement leave. The individual must be employed for at least 30 days, and they can take up to 5 days of unpaid leave. And family member means spouse, child, parent, sibling, grandparent, grandchild, domestic partner, or parent-in-law. And this does not need to be consecutive days, but it must be completed within 3 months of the date of death. And within 30 days of that first day, the employer can request some sort of, documentation if they feel that it's
This still doesn't extend to dogs and cats yet, right? But in California, that's next, isn't it?
Yeah, they're like no fur babies yet. And if you have an existing bereavement policy, that bereavement leave must be taken pursuant to the existing bereavement. But if you don't, then it is going to obviously default to this. And if it's less than 5 days, it's going to now default to be no less than 5 days. Employer prohibitions during workplace emergencies. This protects employees from adverse action in the event of an emergency condition. So employers are prohibited from taking or threatening any kind of retaliation against an employee who has a reasonable belief that their workplace or worksite is unsafe. This protection does not extend to all workers, such as first responders or those required to render aid. The emergency condition means the existence of either the following, and you can sort of imagine like why this came out because of COVID, right? Like what is the timing on this? But emergency condition, it's considered conditions of disaster or extreme peril to the safety of person or property at the workplace or work site caused by natural forces or a criminal act, or if there's an order issued to evacuate, etc. Okay, so then pay transparency. Under the provisions of SB 1162, this requires employers with 15 or more employees to provide job applicants with access to salary scales for any role posted. The idea was to give potential candidates greater transparency when applying for positions so that they can make more informed decisions about career paths and earning potential. Employers are required to maintain accurate records pertaining to job titles and wage rate history for each employee throughout the duration of their employment and for 3 years after. And by the way, private employers with 100 or more employees were already required to comply with this requirement. So it's just extending that to everyone else at this point who has more than 15 employees. The next one I have is contractors disciplinary action, which is AB 1747. And this added language stating willful or deliberate disregard of various state building, labor, and safety laws that exist outside of the license law as a cause for disciplinary action. It authorized the CSLB to assess a civil penalty of up to $30,000 for the willful or deliberate disregard of the various state building, labor, and safety laws, and amended Business and Profession Code 7099.2 and 7110.
Now that is one of their that is the highest or one of the highest penalties they have available to them.
Mm-hmm.
Wow.
Because otherwise, the other part of it is saying, notwithstanding this particular section, the civil penalty shall not be assessed at more than like $8,000. So that gives you an idea that the willful or deliberate disregard is taken very seriously. And then the last one is the off-duty use of cannabis. So if this one's actually more recent, as effective as of this year, an amended California Fair Employment and Housing Act to make it unlawful for an employer to discriminate on the basis of a person's use of cannabis off the job and away from the workplace, or based on an employer-required drug test. It does allow an exception for pre-employment drug screening. And, largely it's so that the work performed doesn't extend, but certain employees are exempt, like those in the building and construction trades, for obvious reasons, and those whose positions require a federal background investigation or clearance. And we are now at the questions portion. So I don't know if there are any other questions that were raised in the interim.
Well, I think everyone should take a moment and copy down your email address and the phone number, and the copy of this presentation is recorded. If you ever want to go back to it, it'll be on the PHTA website that we have for CPSA. These guys, I've worked with the Green Law Group for probably 15 years or more, helping with liens on homes and helping with as an expert both in defense of contractors and for plaintiffs as well. So it's a good group, and I'll vouch for them being true professionals in the industry. I think we've addressed. Someone asked if the PowerPoint is at that site. The PowerPoint would not be. That would be intellectual property of the Green Law Group, but the video can be seen, and you can share it with anyone who's a member of CPSA. And if you wouldn't mind just going to the next slide. I do want to thank Leah. I really want to thank you for doing this for us today. This was really, really good. And I think we talked about next year expanding on it with home improvement contract requirements, and then maybe one a little later in the season on mechanics liens, how to file them, what they mean, what your rights are, and how you collect if you actually go down that path. I do know, folks, that we are going to be in Dallas coming up in November from the 11th to the 14th. We will be at the Pool and Spa Industry Show, and then we'll be at the Western Pool and Spa Show February 6th through 9th. And for those of you who are golfers, please join us for the February 5th golf tournament. That'll be at Skylinks in Long Beach, and you can register at the link here posted on the screen. If you could go to the next slide for me, please. We do need more members of the CPSA. If you're not a member yet, please join our group. It counts as PHTA membership as well. You get a free ANSI standard each year. You get a free submittal to the National Design Awards. And there are many, many, many other benefits, including webinars like these. We are working hard behind the scenes to represent the California pool contractors with maintaining water availability for building pools, and for fighting the decarb stuff where they're pulling natural gas out of the backyard. Our big battle right now is to try to keep gas heaters for swimming pools. Seth Ewing is the contact. Anything you have questions about with CPSA or PHTA, Seth is a great contact for that. Next slide, please. I think that was very similar to the last slide.
Yes, it looks exactly the same.
Okay, next one.
Yeah, that's the end.
That's it. That's the end. All
The
right.
end.
Okay, well, yeah, that's it. Okay. Thank you very much, everyone, for attending today. I appreciate all your questions. And your input for future classes and future webinars is welcome as well.
Thank
Thank-
you so much for the opportunity and taking the time to be with us today. I appreciate it.
Thanks. And you timed out just about perfectly. We're right here now.
Perfect.
Thank you. Good night, everybody.
All right. Good night.
Thank you, everybody.